have it now in the platform. She left the meeting platform. Mas Atta, Mas Atta? Okay. Bapak, Dr. Nas lagi keluar lagi Pak dari platform.
Dr. Nas, yeah. I think we can start.
Okay, sure.
Yeah, she will be the second.
Okay.
So.
All right. Good afternoon, everyone. I am Desi Hanara from ASEAN Parliamentarians for Human Rights. We are pleased to welcome you to the third session of the online conference on freedom of religion or belief, entitled Blasphemy Law, Protection or Criminalization. This conference is proudly co-organized by the International Consortium for Religious Study, the Indonesian National Human Rights Commission, the Indonesian Legal Aid Foundation, ASEAN Parliamentarians for Human Rights, Human Rights Working Group, Center for Religious and Cross-Cultural Studies of the University of Gadjah Mada, Sepaham Indonesia, and Southeast Asia Network on Freedom of Religion or Belief. Ladies and gentlemen, international experts, human rights bodies, and organizations have documented how blasphemy laws often prove to be applied in discriminatory manner. In Indonesia, according to Human Rights Watch, more than 150 people have been convicted under the blasphemy law since it was passed in 1965, and those were mostly from religious or belief minorities. In 2020 alone, despite the COVID-19 pandemic, criminal resort to blasphemy is reported to remain prevalent. Based on the report of the Indonesian Legal Aid Foundation, there are at least 38 cases of alleged blasphemy that were reported to police or other institutions in this country. Currently, the Indonesian Parliament is considering the draft Penal Code, which contains a number of highly problematic provisions, some of which seeks to expand the provisions on blasphemy. Against this backdrop, we are holding this session to discuss international norms and practices in relation to blasphemy law. This discussion will examine the position of Indonesian blasphemy law and the draft penal code from the viewpoint of international human rights law. We hope to explore viable strategies to enhance the protection of freedom of religion or belief, along with other related rights that are implicated by the blasphemy law. Before proceeding to the discussion, I would want now to invite Dr. Zainal Abidin Bagir, the Director of the International Consortium for Religious Study, to deliver his opening remark on behalf of the co-organizers. Over to you, Pak Zain.
Yeah, thank you very much, Desi. Yeah, I'm Zainal Abidin Bagir. I'm the Director of Indonesian Consortium for Religious Studies. So I'm representing other organizers of this conference. There's quite a number of organizations working together, and that makes it possible for us. Otherwise, it's really a big undertaking in a short time. But with this collaboration, we can manage to do it. So first of all, I'd like to welcome all of you, the speakers, as well as the attendees. And I'd like to thank you, especially to the speakers, Mr. Ahmed Shahid, Professor Heiner Bielefeld, and Professor Nazila. Thank you very much for being here with us. It's really a great honor for us to have you all here to help us deliberating this important issue. So this is the third session in our conference. We will have another one on Thursday, the day after tomorrow. We know since the beginning that this is not really, this is not an easy issue. We have had religious leaders, members of parliament, representatives from governments, from Ministry of Religious Affairs, for example. Many of them, they understood well the problems with our blasphemy law. But they also understood that it's not an easy matter at all. If we don't want this, or we think it's discriminatory, it is not. We need really strong arguments to argue for it, but also what should be in what law, what system that we in the past have dealt with using the blasphemy law. As Desi has mentioned, the trend of the blasphemy law in Indonesia, which we discussed last week, is really worrying. It's increasing day by day. Before 1998, compared to after 1998, when we have democratization, it was increasing, the cases. This year, even during the pandemics, there's also quite a number of cases involving blasphemy law using different laws, not only the Penal Code. So realizing that this is a big issue, and I'm looking forward to listening to you all. So yeah, thank you very much. Please, Desi.
Thank you very much, Pak Zainal, for the good introduction of this series of advocacy, as well as setting the scene for the discussion for today. Ladies and gentlemen, we are extremely fortunate to have the presence of the international expert and the United Nations mandate holder at this session. And I have the honor to introduce the three excellent speakers of our session. The first speaker is Dr. Ahmad Shahid, who is the United Nations Special Rapporteur on Freedom of Religion or Belief. Dr. Shahid is a prominent politician and a career diplomat. He has twice held the office of Minister of Foreign Affairs of the Maldives, and previously he served as the United Nations Special Rapporteur on the situations of human rights in the Islamic Republic of Iran. And the second speaker is Dr. Nazila Ganea, who is the Associate Professor in International Human Rights Law at the University of Oxford. Dr. Naz is currently serving as a member of OSCE Panel of Experts on Freedom of Religion or Belief. She has numerous distinguished publications on FoRB and has acted as a widely recognized expert in various sectors of human rights for the United Nations, UNESCO, Commonwealth, Council of Europe, and the EU. And the third speaker is Professor Heino Belfort, who is the Professor for Human Rights and Human Rights Politics at the University of Erlangen, Germany. He previously served as the UN Special Rapporteur on Freedom of Religion or Belief, and has a wide range of human rights and academic career with German Institute for Human Rights and various academic institutions in Germany, as well as globally. Without further ado, I would now invite Dr. Shahid, who will present the international norms related to blasphemy law, highlighting the key argument against the blasphemy laws. And we would also like to hear from Dr. Shahid about his thoughts on Indonesian blasphemy law and explore some of the viable alternatives to the blasphemy laws in view of its discriminatory nature to the minorities in the country. Over to you, Dr. Shahid.
Thank you very much, Desi Hanara. Good afternoon and good morning to all. First of all, thank you, the co-organizers, for inviting me to join this panel. It's a real honor always to join subject to freedom of belief. I wish to use a PowerPoint presentation in my talk today. So if I may share my screen with you. Right, here we are. Thank you very much. I've been asked to reflect on 4 interlinked questions for today. First is, of course, the normative standards on blasphemy laws, followed by a look at, why we should be abolishing, repealing blasphemy laws, the case against blasphemy laws, and then the Indonesian context, especially with regard to how Indonesia might implement its obligation under international human rights law under freedom of belief in the context of its blasphemy laws. And then finally, I'll look at viable alternatives to whatever is being sought to be protected through blasphemy laws. But I want to begin by looking at some international trends in this area. A study done a few years back showed that some 71 countries at that time had laws that can be easily recognized as blasphemy, anti-blasphemy laws. Since then, a few of those countries have repealed them. But then, of course, many laws are not always framed as directly recognizable as anti-blasphemy laws. They take many forms. Some are, as we know, called defamation of religions or religion type or offending religious sensibility, the most straightforward blasphemy law. In other cases, they have coupled with blasphemy laws, anti-conversion and anti-apostasy laws. And then they mask it even further by framing them as public order offenses, sometimes in some contexts, perhaps even called religious peace provisions. Then, of course, we also see in some cases the use of counter-extremism, counter-terrorism laws to essentially have the same impact. Then, of course, what's more, I suppose the trend is using hate speech laws, which again, while there can be a legitimate reason to have hate speech laws, are also used or abused for this purpose of suppressing criticism of religion or what can be called blasphemy laws. And of course, the penalties also range quite broadly across the world. In some cases, it can be simply a matter of fine, of a simple fine, or it can be even a much bigger fine than a simple fine. But in other cases, the liability is increased. It can lead to loss of employment. It can lead to loss of property rights, including inheritance rights. It can also lead to loss of citizenship, loss of family rights. So it can be, the courts can enforce a divorce, or one might lose child custody rights. And then, of course, there's imprisonment in many countries, and in some cases, even the death penalty. And of course, as the penalties rise, then the level of public temperature against a person so accused also increases. And you see a lot of cases of mob violence, vigilantism, ranging from physical assault to just outright, death, killings happening on the back of blasphemy laws. So in terms of the global trends, we do see a mix. I think one could say that the European trend is to repeal them. We've seen Ireland, we've seen Denmark, we've seen Greece, step down and eventually repeal them. We have the UK. In some parts of the UK, it's not an offense. In other parts, it is. And there are countries like that as well. But then, by and large, in what can be called advanced democracies, the penalties aren't that severe. Although I would say in some countries in Europe, we do see now some concerns about including imprisonment for alleged blasphemy. But as we go further away from, say, more established democracies, then the kinds of trends are that they become more severely implemented, including using new platforms to implement them. For example, in the online world, there can be new ways of policing people's expression. There can be new gadgets used to perhaps report on what can be called offensive speech. So by and large, I think the trends are quite disturbing with regard to the use of blasphemy laws in various ways. The normative standards, I think, are quite clear. As Desi Hanara said, and Dr. Baghi said at the start, there's a very clear international norm against blasphemy laws. So we have a Human Rights Committee, which is mandated to monitor state compliance with the ICCPR, say in their clarification of Article 19 for expression, say in General Comment 34, that prohibitions of displays of lack of respect for religion or other belief systems, including blasphemy laws, are incompatible with state obligations under international human rights law. Of course, there is a very narrow exception, which has to be very carefully again understood, except where such speech may reach the thresholds stated in Article 20 para 2 of the Covenant. In other words, where it amounts to incitement to discrimination, hostility, and violence against other people. So it's only in that context that speech that can be seen as offensive to religion could be restricted, but blasphemy laws per se are incompatible with the human rights law. We have a very good report by Professor Heiner Bielefeld, I forget the year now, a few years back, looking at the overlapping of the rights between freedom of expression and freedom of religion or belief, which really explains why it's wrong to have blasphemy laws and why it's so important to protect freedom of expression, even from the point of view of freedom of religion or belief. And of course, whatever prohibition that states bring along, even in the context of Article 20, para 2, must still comply with the requirements on Article 19, paragraph 3, which I'll come to in a bit. Now, of course, what is Article 20 is a very narrow type of prohibition. It only permits advocacy of hatred that amounts to incitement to discrimination, hostility, or violence. Now, the key thing to remember is, I'm borrowing from Professor Jeroen Temperman here, who was, I think, going to be with us earlier. He clearly points out that incitement is clearly a three-party offense at the least. It's not a case of me speaking something that an audience finds offensive and wants to get at me. That's not incitement. That's just, speech that is perhaps offensive or whatever. But it cannot qualify as incitement unless there was a three-party to it, unless a speaker identified an audience for vilification or hatred and actually incited a third party to go and attack them. So I, as a speaker, must address an audience who are then urged to go and attack a third party for it to constitute an act of incitement. So it has to be a three-party offense. Now, I won't go much into this because I think either Professor Bielefeld or Professor Ghani are speaking on this. The Rabat Plan of Action actually provides detailed guidance, and both Professors Bielefeld and Ghani are actually involved in developing it. It provides a very helpful 6-part threshold test to assess whether or not a particular speech constitutes incitement to violence, discrimination, and hostility. And Article 19.3 again has to be very carefully looked into to see on what grounds can speech be restricted. Of course, freedom of expression is so vital to a democracy, to any society. It has to be protected to the maximum extent possible. And the only ways in which can be restricted are if the state, for reasons described below, have it clearly prescribed in law. It must be clear enough for people to know when they're actually breaching the law. So clearly prescribed in law and necessary only for the following purposes. So it has to be absolutely necessary to protect one of these situations. One is rights and reputations of other people. So it's actually human rights. It has to be about rights of living people or reputation of living people, people who have actually right that can be claimed against a violator using speech to attack their rights or reputations. The other grounds are national security, again, should be seen at a very high threshold, public order, general system of rules that maintains order in society, on public health and public morals. So again, even in these situations, the restriction must be very narrowly tailored and you must demonstrate that actually serves a legitimate purpose. It is necessary to have that. And even in doing so, it must not be discriminatory. Blasphemy laws typically weigh in against one community in favor of another community, so it cannot be discriminatory. Nor can actually destroy the right itself. So you cannot actually destroy the space one has to use expression by using even these limitations. Now, the case against blasphemy laws, from what Desi Hanara said and what Professor Bargir said, is quite clear. As General Comment 34 in para 48 says, it violates a range of rights. It gives some list of examples here. It violates the right to freedom of religion or belief. We see blasphemy laws most frequently used to suppress challenges to established religious ideas or authority. And it often targets the minorities. It often targets dissenters. So it curtails the very, perhaps, right it tries to protect. So it cannot protect one's freedom of belief. It actually undermines them. It clearly undermines freedom of expression because it is censorship in a variety of forms. It often also undermines equality before the law because a majority of community often tries to suppress expression by a minority community, including their own core beliefs. And of course, non-discrimination is built into this. And of course, we also have privacy also violated because of these laws. It encourages people to, pry into people's communications and other forms of interactions that might, for them, offensive speech. So it is very toxic to a whole range of human rights. Then, of course, as we see in many countries, it is a slippery road to repression and vigilantism. Blasphemy laws in their criminal expression is incompatible with democracy and almost never occurs in a democracy. And it also encourages vigilantism. We see in say, Pakistan, we see a case of the fact of having a blasphemy law encourages mobs to take the law into their own hands. It happens elsewhere as well, not just in Pakistan. When you have laws that protect certain speech, certain ideas, then people who challenge those ideas become open to attack by anybody and everybody. We have family members who attack people because they believe that their family member may have breached the blasphemy provisions. Chirian George makes a very good case against blasphemy laws in his book Hate Spin. He has the idea that blasphemy laws provide fertile ground for different types of activity. He points out that there is, first of all, a time lag between the speech deemed to be offensive. So whether it is the satanic verses or whatever else, somebody speaks something that is critical or whatever is offensive to some people, and then you have agents, typically politicians and others who want to use the speech for other purposes, who mobilize people by manufacturing indignation. They create indignation from this speech, and they mobilize people who then go and harm victims. And he takes for 4 or 5 cases, including from Indonesia, to show that the initially speech deemed offensive occurred sometime before the offense was taken, so to speak. So agents mobilize the speech and then direct mobs towards people. So there is this idea of manufacturing hate speech. And he also points out that when people do this, you also create the offense givers who see a cycle operating. So you could be, somebody who just wants to give offense, knowing well that it will create a cycle, ultimately go and demonstrate how bad the community is. So the idea is that step away from this hate spin cycle and look at liberal democratic ways of dealing with this. It will be looking at how, rather than criminalize offensive speech, look at other ways of engaging with this. I will not go here because you have the Rabat Plan of Action that will provide more detailed guidance here. Finally, Indonesia and what it can do. I think it'll be really good to invite a special rapporteur on from Expression to come and visit the country, or mandate to come to the country, or other independent party to come and do a good audit of what's happening in the country. There are good practices, there are also deficits, but a good audit of what's happening is clearly a sound basis to look at what Indonesia can do in regard to its obligation on international human rights law and freedom of belief. Second, human rights education. The Rabat Plan of Action is good for all to look into in detail. The UN now has something called Faith for Rights toolkit, looking at how different religious communities can advance human rights using the humanistic core in their different faith systems. UNESCO has detailed human rights education programs, some of it linked to the SDG 4 on education. And of course, rule of law, a human rights-based approach is essential. Rule of law, simply having a law and enforcing it isn't rule of law. It must be compliant with human rights standards. A gender perspective is essential. You can see the amount of times blasphemy laws are invoked in ways that undermine gender equality rights. Women, girls, LGBT plus persons are frequently targeted using through blasphemy laws. Then we have one of the earliest rapporteurs making a recommendation of forming grassroots committees of faith-based groups and other society actors or lawyers, others coming together as a preventive mechanism to look at what's happening in the communities to build social capital in that community. Finally, the state-religion relationship. All countries ought to look at how that also complicates a space for expression. Professor Hannah Bielefeld used a term, respectful distancing between state and religion, as the ideal way, the best way, I suppose, to look at this, in the sense that state is neither neutral as such, because neutrality can also, I beg your pardon, state isn't secular, because secularity can also be used as secularism as an ideological tool, but distancing between state enables it to give equal protection and equal treatment and equal respect to all communities concerned. My very last slide, alternative, I just present to you the Article 19 hate speech pyramid, which shows the different ways in which to respond to offensive speech. Some speech, though offensive, is protected because Article 19 does not allow them the threshold that they have provided. So speech that we don't like must still be tolerated or accepted, or at least not in any case have a legal provision against that, because that is so fundamental to democracy and human rights. Then there's speech that may be restricted, but not necessarily obligatory when it comes to issues of public order and so on and so forth. And then there's a level in which it is prohibited. So state must actually, under Article 20 of ICCPR, prohibit them. And finally, there's the Genocide Convention, the requirements for prohibition of that. So there is a sliding scale of responses to offensive speech is perhaps what is best alternative here, and really asking oneself, what are we trying to protect here? And is it something more important than human rights or a human being trying to protect here? It has, states' obligations are to protect human beings. The minute we try to protect ideas, and I think we have to ask ourselves, are the ideas themselves worth protecting? Or which idea really worth its sort requires protecting? And what happens when we try to protect ideas instead of people? So I shall end there. Thank you very much.
Thank you very much, Dr. Shahid, for a very comprehensive presentation and for highlighting the relevant international norm relevant to blasphemy and describe how it's been really toxic on the wide range of human rights. And well noted on the recommendation. Indeed, that's very helpful for us because, as mentioned earlier, that out of this series of conference, we are planning to do a focus group discussion, focusing on trying to come up with concrete recommendation, especially that the Parliament is considering the Penal Code, and we are trying to come up with viable alternative wording to the Penal Code. And of course, what you mentioned as hate speech law that is in compliance with Rabat Plan of Action, and also the action plan, Human Rights Council Resolution 1618, that should be our basis in crafting the alternative wording for the draft Penal Code itself. And of course, we are working hard. We will work hard to try to invite you to Indonesia to do the audit and to get to know Indonesia better and inside us better as well. So with that, I will now hand the floor to Dr. Nazila, who will elaborate on the significance of the developing norms related to blasphemy as contained in the Resolution 1618 as a landmark agreement that was adopted in 2011 to combat intolerance on the basis of religion or belief, including some of the follow-up resolution, as well as the Rabat Plan of Action. And we hope Dr. Naz will also be reviewing some of the challenges in the implementation of the action plan under Resolution 1618 and share us her insights on what Indonesia could learn and implement from those norms that have been covered earlier by Dr. Shahid, as well as the Resolution 1618 and other norms that I mentioned earlier. Over to you, Dr. Naz.
Thank you very much, Desi Hanara. It's a pleasure to be in your company. You are a champion of freedom of religion or belief, not only nationally and regionally, but also at the international level, and we appreciate all your efforts. Professor Bagir, Professor Bielefeld, Professor Shahid, lovely to be in your company. I'm going to actually echo many of the things that Professor Shahid already shared, but really what I'm looking at is why we are still struggling with this. If we are struggling with this question at the domestic level, then you can be assured, and you will see that also at the international level, this continues to be a debate. Perhaps if the norms around this that we're going to share now, and Professor Shahid already raised, if they had been settled and clear 70 years ago, perhaps we wouldn't be here now. Basically, the clarity that we developed, or the norms that we developed over the last decade, if we had them at the outset of the United Nations some 70 years ago, maybe we would have been more advanced in our thinking and application of this area of work. As Professor Shahid was suggesting, we seem to rush towards a legal solution to these problems, whereas if we are genuinely concerned with the underlying human rights issues of hatred, incitement, violence, public order, we would be looking at a far greater range of responses. And I think the norms that were developed over the last decade points to how embedded the genuine, not the blasphemy laws can harm minorities, but I would also say that it's also persons who consider themselves majorities, because the compromise and what is sacrificed often towards populism and, you know, a political current that is whipped around blasphemy accusations compromises fairness and justice and the rule of law. So, you know, of course, at the front line of the victims of that are often minorities, but it doesn't mean that majorities are exempt. Once you are submitting to just, I think, Professor Shahid called it, you know, it's like a vortex, isn't it? It's like a cycle that is created. Once that cycle is created and, you know, somebody considers that this is an opportune moment to whip up some, you know, blasphemy concerns, then the victims can be multiple. And the standard of proof required is suddenly forgotten because of that popularity. I will share some slides just because of the range of norms that we are referring to, and really for a reference point for your future focus group discussions. And I will step back a little bit to look at the history of how we, you know, what were the debates over the decades at the international level that led to a number of normative clarifications over the last decade. And what I'm sharing is mainly soft law instruments. The hard law instruments were already shared by Dr. Shahid. And if I move it to slideshow, then we're better off. Okay, so the concerns of the United Nations over the decades have been regarding, you know, discrimination on the basis of religion or belief. But then we, some 20 years ago, this topic was introduced as what is defamation of religion and how would that differ from incitement, as captured in Article 20 of the International Covenant on Civil and Political Rights. A range of expert conferences and events were held over many years to break a deadlock between really, we could say, the Western Bloc and the OIC, because that's where the tension primarily lay. But of course, other countries then found themselves on one side or other in that. And the UN became, the UN Human Rights Forums became really divided on this issue for many years. And these expert conferences were held over a number of years to try and break the deadlock. It has been described by a number of people in the Office of High Commissioner for Human Rights as requiring the largest research attention and funding and sustained attention of any topic over the years at the United Nations, which is quite startling that it should cause such division, let's say. And the 1618 Resolution and Action Plan, the Istanbul Process, and separately the Rabat Plan of Action came as a response to it. I'm drawing a lot from a report by the Universal Rights Group on combating global religious intolerance, implementation of Resolution 1618. Although the report is a few years old, it's quite effective at summarizing the history of this topic at the international level. So the context, of course, at the international level, we see, unfortunately, anti-Semitism, other hatred, attacks, and you know, populism, whipping up hatred. This is a live wire issue around the world. And one may see, you know, one may see blasphemy laws as an easy, simple solution to these problems, but really it isn't. And if anything, it aggravates many of the human rights concerns even further. It might be easy as a policymaker to think that, oh, we passed the law, we solved the problems, but it really doesn't. So this is the contemporary importance. Historically, in 1946, the Economic and Social Council raised its concerns about the need to prevent discrimination on grounds of both race as well as religion. And these were concerns that it asked the Commission on Human Rights to look at. Some years later, and separately at the subcommission, Arkot Krishnaswamy produced a report on freedom of religion or belief or religious discrimination. And although, you know, it is many decades old, the richness of his study of religion in society, discrimination on the basis of religion or belief in society, how it implicates a wide range of laws, including penal codes, but also, you know, personal status laws, family laws, how embedded the question, if we are going to be serious about discrimination on the basis of religion or belief, we would look at the whole range of laws at the domestic level and address all of them. Of course, in parallel, in tandem with education, social and other policies. In 1981, there was the adoption of a UN declaration. And in 1986, the mandate that Professor Bielefeld and Professor Shahid have held was created. 1999 was a flashpoint in relation to this issue at the international level, where a resolution on defamation of religions was proposed. Again, it was proposed as if this will solve all the range of issues of hatred and intolerance and prejudice and discrimination and violence on the basis of religion or belief. It was put forward as if, you know, it would be some kind of blasphemy law for the international arena. But it caused some decades of division before our normative response tried to at least provide a framework of response that, after all, you know, it should also be compliant with other human rights. All human rights are universal, indivisible, and interrelated. We cannot protect freedom of religion or belief if we sacrifice totally freedom of expression, minority rights, and other issues. The 1999 resolution, of course, then when there was the 9/11 attacks and the subsequent political changes and responses in various parts of the world, it only sort of fed on that. And there were legitimate concerns about Islamophobia that got wrapped up into this defamation resolution. But the defamation resolution, we should remember, preceded it. So it was not a response to 9/11 concerns. We should remember that. The two political streams of OIC versus other, if you like, became a very simplistic divide between shall we protect freedom of expression or shall we protect religion? And, you know, the dismantling this with a human rights friendly lens became a long project. It was finally in 2010 that the political breakthrough between the OIC and you know, the bloc that had been created at the international level, the breakthrough came 11 years later, you know, not 1999, in 2010. And this was hailed as a triumph of multilateralism because really it was tense. And if you can watch the webcam of that, there were accusations of, you know, people having genocide and blood on their hands. You know, those kind of accusations became very easily thrown around at the international level between different actors, which was not at all helpful in advancing the human rights agenda internationally. It poisoned the Human Rights Commission for many years. I think we can just simply put it in that language. And along with Resolution 1618, this breakthrough resolution was an action plan. And the Istanbul process was going to implement and realize and advance the objectives of the 1618 resolution. And 7 meetings have been held so far in different parts of the world in addressing this. Really, these Istanbul process meetings were meant to be opportunities from one another. Unfortunately, some continue. The Geneva game, it was part of the Geneva game the poison was cast very deeply in Geneva at the Human Rights Commission, and it was there that the resolution was brokered. However, its implementation mechanism concerns all of us at the local and national levels, and it provides helpful guidance. I wouldn't say it's perfect because, you know, these resolutions come with a lot of political compromise, but nevertheless, 10 years on, it still gives us a helpful work plan that we can use and benefit from at the local and national level. But more importantly, we can share our experience from the local and national level to benefit the international debate and make the international debate of the implementation 1618 and Istanbul process real and practical rather than political hype and polarizing debate. The consensus has been maintained. It is not easy, but there have been positive steps that we observed already in the report some years ago and also continue now. So many states have established national mechanisms to address intolerance on the basis of religion or belief. Many states have taken a range of steps to promote interfaith dialogue. And I think interfaith dialogue can be helpful or it can be tokenistic. And, you know, I think it is for yourselves on the ground to see, is it elitist, formalistic, and just for show, or is it really advancing challenges and easing and promoting understanding and the breakdown of prejudice at the local and national level? What has also been very noticeable has been that there has been more attention to speaking out against acts of provocation, stereotyping, and insult at all levels and by politicians and other actors at the highest levels. And I think, you know, we rush towards a blasphemy law solution, thinking it will be a solution, but actually what we need are many other measures of reassurance, of calming, and of condemning provocative speech. And that can be hugely helpful in stemming the tide of yet another international, you know, disagreements around insult. If you know, there have been many, the Danish cartoons are an old example of this, but it comes up every so often that there will be a provocative act which is which will be taken as, which will be considered insulting and offensive by some persons or some groups. And if appropriate, if that is appropriate, then political and other actors speak out against it. That will often moderate the possible response. And what Professor Shahid was talking about earlier, that if some are only waiting to fabricate, you know, being hurt and get political advantage out of it, by speaking against it at the highest levels appropriate, we put a stop to that or reduce the chances of that. Interfaith and intercultural dialogues at different levels always play a role in what Professor Bielefeld refers to very helpfully as positive investments in society for the true enjoyment of freedom of religion or belief for all. And we have many examples in that report of speaking out, and you could consider it if it's helpful. Now, in addition to the 1618 resolution and Istanbul process, we have the Rabat Plan of Action. This considers the distinction between incitement to hatred and freedom of expression. And it's very helpful contributions, as the UN High Commissioner for Human Rights, Michelle Bachelet, has said, is that it gives threshold tests and recommendations. And especially in the digital landscape, that is even more important to us. Because why? Because we don't know the weight sometimes and feeling of insult by it, if you see what I mean. So sometimes we feed a provocative, let's say, film or speech, we feed it by saying we are hurt. And if we had just left it alone, we would find that the speaker and the film and all of that is pretty negligible and would get no attention. And the Rabat Plan of Action benefited from many expert papers and research studies over many years. In fact, in the 5 years prior to it, there were conferences held in Geneva, Vienna, Nairobi, Bangkok, Santiago, that looked regionally, legally, socially, educationally at different aspects of this issue. So it also stands on the shoulders of all of those reports, and I do recommend the action plan to you. I also am referring to some of the slides that Professor Shahid shared about, you know, let's not, Rabat reminds us that not everything is incitement. Blasphemy is not interchangeable with the legal standard of incitement that requires certain state actions, according to the International Covenant on Civil and Political Rights. And I will pass by it because Professor Bielefeld, I'm sure, will come to this, but the Rabat Plan of Action reminds us of the incitement threshold test. So when we are looking at what is incitement according to Article 20 of the International Covenant on Civil and Political Rights, we should consider the social and political context. We should consider the speaker, their status, their influence. We should consider the intent of the speaker, the content and form of the expression, the extent of the expression, and the likelihood of imminent violence, discrimination, or hostility occurring as a direct consequence of the expression. All of this becomes more difficult when it is communicated to us across oceans and if it is digital, right? But let's not fool ourselves that everything is incitement. We just look at 5 words from a speech and we know that it's incitement, and the politicians run on this. That is really not an adequate judgment of what is incitement according to Article 20. All of these aspects should be brought together. So the threshold for defining restrictions on freedom of expression and incitement to hatred and the application of Article 20 of ICCPR through thorough reasoning given in the Rabat Plan of Action is set very high. Now, just to end, and I know I've skirted around many of these norms, but I hope it will give enough food for discussion and time for discussion, most importantly. 5 years after the Rabat Plan of Action, we had the Rabat +5, and from that developed a very useful framework of faith for rights, which specifically considers the many actors that should be involved in responding to discrimination and hostility, okay, according to Article 1618, Resolution 1618. 1618 points out the role of different actors, that when there is insult and hatred or discrimination, many actors should become active in society and should already, frankly, have been active in society. One of those actors that can play a positive role rather than just throw up their hands and shout blasphemy are faith actors. Faith actors have a crucial positive role. Framework and toolkit that the Faith for Rights website proposes to us that we can, we can put into action tomorrow in terms of advancing different faith actors and faith-based organizations in society, and advancing deeper reflection and action and solidarity that will positively affect the environment that concerns us and make sense of it for me. Thank you.
Thank you. Thank you very much, Professor Nas, for sharing some historical context, including some of the world tragedies, heinous tragedies, I would say, which lead to a various processes at the international level, and eventually resulted in the triumph of the multilateralism, which is the Resolution 1618. And it's very useful also for you to share the state of implementation of the Resolution 1618 and how it actually, how you see it as an opportunity for the national actor to actually showcase that they can give more commitment and buy-in to ensure the implementation of this resolution. As I mentioned in the beginning, I'm myself working at the regional level, but I'm personally deeply encouraged with the big undertaking, as Dr. Zainal mentioned earlier in the opening. It was really planned in a very short period of time, but it has been resulting in a quite promising steps, and we have been able to generate commitment and buy-in from the local stakeholders and as well as the local actors on the ground. And thank you very much, and just would like to inform you as well that we at ASEAN Parliamentarian for Human Rights are currently translating all the international standards that you mentioned earlier, the Rabat Plan of Action, the Fed for Rights, Article 19 Toolkit, in some languages in the region in the effort to raise more awareness, because as you said, really this is a big issue and it requires a greater range of responses and also multifaceted effort to be done. So with that, thank you very much again, and I would now hand the floor to Professor Bellefield, who will be explaining about the rights that are being threatened by blasphemy laws, and also share his observation on the main difficulties in abolishing blasphemy laws. And in addition, we also know that in Indonesia, one of the is that this is being enforced for the sake of protecting public order. So in this regard, we would also want to hear from Professor Bellefield on the alternatives to blasphemy laws in terms of the protection of public order. Over to you, Professor Bellefield.
Yeah, thank you very much, Daisy. And let me start by congratulating the organizers and thanking the organizers for having us brought together to this wonderful convention and to this important discussion. So I appreciate the efforts. And also I'm very glad to see also a large audience showing an interest in these discussions. So I think this is great. And I'm also very happy to be here together with my esteemed colleagues, Nazila Ghanea, Ahmed Shahid, Zainal, and many of you. So thank you very much. Now, the previous speakers, my colleagues, my esteemed colleagues, have already covered many of the important issues. So actually, I think I can be brief. And I would like to start on a rather personal note. And first of all, say, I am a religious person myself. I'm a religious person, so I have religious feelings. And I do sometimes experience my religious feelings being offended. So in that sense, I do have access to the phenomena of blasphemy. I don't deny the experience of blasphemy. Actually, I share that experience from time to time. So in that sense, I do believe in the reality of blasphemy. I do not believe in blasphemy laws. It may be important to highlight that distinction in order to avoid misunderstandings. That's why I'm saying that. Let me give you two examples where I actually felt this was blasphemous. The one example, I think you all know it, was when the US President Donald Trump grabbed a copy of the Bible, standing in front of a church, pretending to defend faith, just for political gains, for political marketing purposes. I felt this was blasphemous. Not everyone agrees, and maybe that's part of the problem. Usually we don't disagree of what is blasphemy and what is not blasphemy. I felt this was blasphemy. actually, I liked the spontaneous reaction of the bishop in charge of that very church, who immediately said, okay, we did not invite the US president to give us his protection, or so-called protection. We did not invite him, and we don't think that the message he is conveying as he stand for. She was very explicit, the bishop, in rejecting that attitude. And I think this was the most important, and I think the only meaningful response to an act that I personally would consider blasphemy. Not everyone agreeing on that. Yeah? I think it was an adequate response. It was a strong response. Of course, I would have liked to give that even more echo. I mean, it did get some international echo. Actually, I would have liked more echo on that. Yeah? A broader echo, a wider echo. Let me give you another example now from Russia. I mean, the Russian President, Vladimir Putin, being involved in all sorts of power games, also from time to time likes to invoke religion. And high-ranking clerics of the Russian Orthodox Church actually played that game and praised him, even using religious language, something like God's miracle, Putin as God's miracle. Again, I felt this as blasphemy. Now, Russia does have blasphemy laws in place. Would they ever apply these blasphemy laws to respond to such claims? Of course not. Of course not. The blasphemy laws in Russia are merely used against minorities, against critics, against dissenters. And that's part of the reality. So I do believe in the reality of blasphemy, an experience that I from time to time share. I have strong feelings about that. But I think blasphemy laws is an entirely different issue. And I think here we have to be very clear about that. Blasphemy laws. I mean, blasphemy laws can merely create confusion and create damage. And that was already said before, so I sign up to everything that Ahmed Shahid, Nazila Ghanea had already pointed out. And one question that also Daisy repeated, and I received those questions beforehand, was, I mean, which rights are threatened? I mean, the usual assumption is, of course, blasphemy laws threaten freedom of expression. Rightly so, I mean, it's true. Yeah? So freedom of expression always seems to be the first candidate for a human right that suffers from the chilling effects of blasphemy laws. Okay, that's true, but it's not the entire truth. Because freedom of religion too is affected. And that is really an important message. Because also during the discussion, repeated just a moment ago by Nazila Ghanea, the discussion on defamation of religions, combating defamation of religions, discussions that stretch over a decade in the UN. Very often the impression emerged that here we have freedom of expression and here we have freedom of religion. Two rights, not only distinct, of course they are distinct, but maybe actually antagonistic. So curbing freedom of speech could be in the interest of freedom of religion. And I think this is a highly dangerous misunderstanding. It's a highly dangerous misunderstanding, because if you pit of one right in principle against another right, you end up destroying the whole system of human rights. And just a moment ago also Nazila cited again the famous formula coined at the Vienna World Conference that all human rights are universal, yeah, but then also are indivisible. They are positively interrelated, they are interdependent. So you cannot work in favor of freedom of religion by at the same time pushing aside freedom of expression, or the other way around. So one has to stick to a holistic agenda. That's very important. During the discussion on defamation of religions, Asma Jahangir, Special Rapporteur on Freedom of Religion or Belief from 2004 to 2010, so she was the one in the midst of that discussion. She made a very important contribution by pointing out, and now I quote, "There is no right to be free from criticism." I mean, freedom of religion or belief cannot mean a right of religious people to be free from criticism. I think religiosity free from criticism, actually it would be blasphemy in my view. It would even be blasphemy, yeah? Having a religion free from debate, free from criticism. Yeah? So somehow, there are complications, as we know, but freedom of expression, freedom of religion can only be pursued, can only be promoted, protected in conjunction. And I think that is really a very, very important message. And Asma Jahangir, who came from Pakistan, by the way, a country with a draconian blasphemy law. She also, I mean, she gave examples saying, I mean, who are the ones suffering the most from those blasphemy laws? Journalists, sure, I mean, those are the typical representatives of the media, freedom of expression, but then also religious minorities, Ahmadis, Christians, but also Muslims that have who have a different view. I mean, somehow criticizing also the politicization of Islam as it happens in Pakistan and other countries, to the detriment of religion, in fact. Harnessing religion for political gains, to the detriment of religion. So in fact, it's also the religious community. And here freedom of religion or belief is not less affected by those pernicious blasphemy laws than freedom of expression, no less. Yeah, so she gave examples to actually back up that claim that we need to stick to a holistic agenda where all these rights are somehow positively interrelated. Yeah? You cannot work for human rights without appreciating freedom of expression. Of course, I mean, people have to have the possibility to voice their concerns, to voice their grievances, to participate in public debates. I mean, otherwise, no culture of human rights will ever flourish. But at the same time, you cannot have a culture of human rights without appreciating that very important dimension of human life. Human beings are beings with convictions, with deep convictions, identity-shaping convictions for individuals, but also for communities. So it's an important part, again, freedom of religion, freedom of expression, somehow in tandem. Knowing it's not always easy, life is never easy, yeah, but we have to stick to that holistic understanding. Now, another question given to me beforehand and also repeated by Daisy a few minutes ago is, I mean, what's the difficulties in abolishing blasphemy laws? Let me just mention one point, and that was the point I already made in the very beginning. Maybe we have to be clearer about the fact that the abolishment of blasphemy laws or the appeal to abolish blasphemy laws does not deny the reality of religious feelings being hurt. Yeah? Because, I mean, I've quite often come across that misunderstanding. Okay, here we have the religious people, and then in the other camp we have the more flippant people who don't care. Yeah, and they would be the ones advocating for the abolishment of blasphemies. No. As I said, I'm a religious person. I know what it means, having one's feelings hurt, offended. There is a reality. But as a religious person, as someone also very much advocating freedom of religion, I think blasphemy laws is a wrong answer to legitimate questions. It's a pernicious answer. It's a destructive answer. It creates confusion, destroys understanding of blasphemy laws to be abolished does not deny the reality of blasphemy. So we have actually to develop new responses, different responses, alternative responses, more creative responses. And all of these were already covered in a sort of typological shorthand, yeah, so interreligious communication, education, sensitization, public outreach measures, tackling the issue of hate speech. But that's somehow a different category, hate speech. Yeah? Incitement to hatred, in acts of hatred, violent acts of hatred. Yeah? So maybe that is really an area where also criminal law sanctions must play a certain role. They don't provide the solution, but they must play a certain role. But it's a different category, different from blasphemy. We should not mix these things. So the last question I was given beforehand is, I mean, now Indonesia. Indonesia, a country also concerned about public order issues. Yes, of course, of course. I was in Indonesia twice, only for a short while, but also I know harmony, social harmony seems to be an overarching purpose, not only in political discussions, but also many people would share that idea of a harmonious coexistence. Now, let me say, human rights are not against public order. Actually, they redefine public order. Human rights are not against social harmony. They redefine social harmony, actually advocating for a more demanding understanding of order and harmony and harmonious coexistence, because a real harmony must be one that also gives breathing space for people, so that people actually they feel respected. They have the possibility to voice concerns, to bring up issues also in public debates. So a real harmony is always a harmony as work in progress. We cannot simply postulate it and then ask people to shut up and respect that harmonious order. No, I think it's something we have to work out. And human rights are a very important element of public order, of redefining public order, of social harmony, of redefining social harmony. A social harmony based on respect for diversity, on respect for convictions, on respect also for the observations that people wish to share, including on complicated issues. So human rights and freedom of religion or belief as part of human rights are ultimately a peace project, but it's a peace based on respect for freedom. So somehow it's a peace that will not be harmonious in that superficial sense of everyone simply agreeing. Yeah? It's a more demanding understanding of harmony as something always to be elaborated, always mobilizing active efforts, requiring active efforts. So a harmony with a little element of noise and with much color added to it. Yeah? So I could quote a famous philosopher, not name him, who once said, "Real harmony cannot be the tranquility of the graveyards." So in that sense, yes, I would say the whole discussion on freedom of religion or belief, also the criticism of blasphemy laws and their adverse effects on a society, are in the interest of maybe a new form of social harmony that we have to actively redefine by interacting and by making maximum use of all human rights, including freedom of expression and also freedom of religion, which both can only flourish in tandem. Thank you very much.
Thank you very much, Professor Heiner, for showing us how blasphemy laws have actually threatened the minorities. and to some extent also the majorities. And being a minority or majority in some country wouldn't be a fixed privilege for us. At some point, we will be moving to different countries and we will feel like we are minority. So I think it's an important message for all of us in Indonesia. And I think that's a really important point as well that was made by Professor Bellefield regarding how blasphemy relates to religious feeling. But regardless, it still remain, the blasphemy still remain as disruptive entrant. And it's not considered as a solution to the problem that are faced within our society, because it creates tension, as we have actually discovered in the previous session by other speakers in last week. And it's also very heartfelt to listen to the alternative viable solution to public order that was earlier mentioned by Professor Bellefield with regard to a new form of harmony, and the fact that harmony should be seen as a work in progress with a little more noise and a much more tolerance. Hopefully, as a country that is tolerant in nature, hopefully Indonesia will be able to absorb more of this, these values moving forward. So with that, thank you very much all the speakers for all the excellent presentation. And now let's move on to the Q&A session. We have received a couple of questions from the audience. The first questions, it's from anonymous audience. It asks about how should Indonesia start the process of introducing a non-criminal sanction approach in the blasphemy law? Are there any countries that can be an example for this matter? And second question, a question from International Criminal Justice Reform. This is one of the leading CSO who have been working very hard. The question relates to the standard of what defined as a public norm or halt. Could be if it hasn't considered as an open norm. How should this open norm be seen in line with the ICCPR's necessity principle in terms of limiting the freedom of expression? And then the third question is from Dr. Zainal. How can you argue that combating intolerance or incitement under Resolution 1618 is an alternative to blasphemy laws? Countries like Indonesia, for instance, may speak out against some type of intolerance while maintaining its blasphemy law. And the argument here in this country is that blasphemy law is not an issue of freedom of religion or belief. Proponent of blasphemy law used to say that you have freedom, but not to defame religion. So I may now give the floor to Dr. Ahmad Shahid to respond to any of the questions. The question from Dr. Zainal earlier was specifically posed to Professor Nazila. However, if other speakers or panelists would want to respond, it's very much welcome. So with that, over to you, Dr. Shahid.
Okay, thank you very much. It's been enlightening to listen to and watch Professor Nazila Ghani and Professor Haina Bellefield. And also thank you for these very good questions. I think, in terms of guidance as to what to do with blasphemy laws, I think the best is to look at the Rabat Plan of Action and see what kinds of expression should be responded in what fashion. The whole concept of blasphemy, if it rests on the idea that religions require protection, I think one has to really challenge that. What precisely is one trying to do? And look at the evidence. What happens in any context in which a government or a country or law tries to protect offense to religious sensibilities? So one has to look at what that leads to. And the answer is that these sorts of restrictions always lead to something negative. That is either censorship, a chilling effect on expression, or worse, it can lead to public, mobs mobilizing people to attack speakers. So the whole idea that one should face a liability for speech that does not meet the thresholds in Article 19.3 and Article 22 is problematic. So then one has to go into, so what kinds of speech can be restricted? If you look at the Indonesian proposals, you have the notion of causing a disturbance outside a place of worship. Of course, if you define it in a very narrow sense, that if you have a mob which will disrupt, impede the free exercise of freedom of worship in a place, house of worship, that's a problem. Impeding one's ability to carry out peacefully the acts of manifesting their faith, that's a problem. But attacks on a religion per se, should be seen differently, because once you have the idea that religions should be protected against attack, means you can extend it to say, oh, therefore we will also prescribe criticizing religion. If you look at all religions, or nearly all the world's major religions, they are so open to different interpretations. There's so many different, if you like, sects or versions or groups that emerge from this, all subject to, over time, different self-definition of religion or different interpretations of those texts upon which those faiths are based. So the minute you curtail, if you like, serious, robust debate about religion, you don't actually contribute to a public good, you begin to undermine a public good. In those countries where there are fines, there are some European countries where fines are imposed. We have recently, a case for the European Court from Austria, where the notion of religious peace was invoked in a fine. But again, the question one has to ask is, what was served by that hefty fine on a person who was, insulting the Muslim Prophet? Now, what was served by that? The Muslim groups in this case did not object to this, at least raise issue with a statement. I'm not saying they agreed with it, but the objection did not come from them. It came from others who would listen to this particular person speak about Islam and the Muslim Prophet. Now, the question is, when you impose even civil liabilities on this sort of speech, does it serve any religious purpose or any public purpose? It doesn't even serve a religious purpose, because once you curtail discussion on an issue, as if you look at the Mill's four-pronged argument, once you actually don't let a challenge come to an issue, then that prejudice or that issue might remain where it was. It's only through healthy debate to actually interrogate and expose, if you are, false ideas, in fact, undermine prejudice. So even notion of civil liability, which tries to protect ideas, I think is not a productive one. But one should look at protecting individuals. You can perhaps use an argument based on religion to harass individuals, to cause harm to individuals. That's when you look at triggering the sliding scale provided in the Rabat Plan of Action, where civil penalties may be justified if it is insult and discrimination against a person which doesn't reach the threshold of where some harm happens to you. So if someone speaks about, say, some community and the need to have them expose some kind of liability, depending on the severity of the harm, then you can fashion your response. So my view is that blasphemy laws work best when they don't exist. It's not to say that hate speech laws shouldn't be there. Hate speech laws which tailor actual. If you look at the jurisprudence of the Human Rights Committee, you have, for example, a case of anti-Semitism from Canada, where a teacher was using this private time to speak out anti-Semitic hatred. And in this case, what the committee found no problem with was an administrative response, that because they found that his speeches and other expression in his private time was creating a toxic atmosphere for Jewish students in the classroom, that they found that rather than penalize him in a, if you like, criminal fashion or even a civil liability, they just moved him to a non-teaching position in school. So ways in which his rights are also to that extent protected, but then those who are affected also feel shielded from, if you like, harm that can happen to them. So you have to look at actual real harm to people. You cannot police civility. What offends you won't offend me. or may not offend me, but offends me may not offend you. And so the law cannot come and decide, where the offense should be. So the best way would be to leave that to, as Rabat Plan of Action does, and as both Professors Ghanea and Bielefeld suggested, to counter positive speech. When someone speaks insulting language towards the whole community, if it doesn't reach the threshold of inciting discrimination or violence, then the response is to stand up and speak. If you look at the Innocence of Muslims film that came out now, I think 8 years ago, you saw in many countries, President Obama's response wasn't to go and call for a ban of the film. He came out and spoke against the film, and when a pastor, also in the US at the time, I think, had this Burn a Quran Day, Pastor, I think, Jones in Florida, I think it was. Again, the straight response was not to arrest him for his call, but to respond to his call, to say why it was wrong and to express solidarity with the Muslim community that the person was targeting. So I think blasphemy laws ultimately get caught in a vortex, as Nas said, of hate spin that only serves the bigots and the hate mongers rather than any people who are vulnerable, who require protection. So move away from blasphemy laws, come to hate speech laws that comply with Article 22 of the ICCPR. Thank you.
Thank you very much, Dr. Shahid. We have to move on from the blasphemy law into hate speech law that complies with the ICCPR. Very clear message. And now I would want to hand the floor to Professor Nazila to respond to some of the questions.
To be honest, that was so comprehensive and persuasive. I don't know if I have much to add, but just to say that, I think we are all saying that the term blasphemy law is problematic and is confusing. I have a doctoral student who has completed now, Tiago Alves Pinto. He spent many years studying what blasphemy has meant from the ancient times until now, what purposes and what objectives, theological, religious, social, political, legal, are packed under, buried over time, what has been expected and either spoken or underlying it behind so-called blasphemy laws over time. And therefore, when a question is asked about blasphemy laws, we have to say, well, first of all, we've considered that this is a contradiction in terms, not because blasphemy doesn't exist, as Professor Bielefeld said, but because a legal response to the many incentives and interests behind a blasphemy law are so complicated, and most of them serve to undermine it. So, the legal response undermines the purpose with which it is supposed, it's supposed to serve. So we're saying the feelings of hurt exist, insults obviously exist, prejudices obviously exist, but packing this all into a blasphemy law that is charged through history and theology and politics and let alone all the resonances internationally, is counterproductive. So what, after many years of struggle, did 1618 resolution call it? It called it combating intolerance, negative stereotyping, and stigmatization of and discrimination, incitement to violence, and violence against persons based on religion or belief. I don't think this is an example of the UN just trying to be complicated. I think we can sometimes accuse the UN of that. But here it was trying to unpack what are the human rights appropriate incentives behind so-called blasphemy laws. What is legitimate in legal terms is to combat intolerance, to combat negative stereotyping, to combat stigmatization, to combat discrimination, and to combat incitement to violence and violence. Against who? Not against religion, because that makes it very selective, and it's not a religion does not have human rights. So against who? Against persons based on their religion or belief. And I think we should focus on that. And then what measures serve to address stigmatization, discrimination, and incitement to violence and violence. What really, honestly serves that? Well, the responses are many and the actors are many. So we need Rabat Plan of Actions. The way it is structured talks about laws, legislations, policies, okay? And all of these are important. And then who are the actors that we need to be active in society to eliminate or address discrimination, prejudice, violence, and incitement? The media, educational actors, equality bodies, NGOs, collecting data, regulatory frameworks, and human rights institutions, and the state, and all of us, frankly, okay? So I think the other thing that Professor Bielefeld kindly reminded us of is that even if we were going to craft the supposed perfect law, it would be based on a static society. And society, even locally, let alone nationally and internationally, is not singular in its preferences or in its religions or beliefs. So it is impossible to have this kind of package measure called a blasphemy law that is conducive to human rights, public order, and society in a continued way. So let's park, we are proposing that we park the term blasphemy law, unpack the interests that we are trying to serve under that title, and then look at them one by one in a rich way, rather than trying to make the law the solution to all of society's problem. That has never worked and it will never work.
Thank you very much, Dr. Nas, for re-emphasizing the point that was made by Professor Bielefeld, but also trying to give further and enrich the perspective. Blasphemy law and insult exist. However, still, blasphemy law is not a conducive for human rights, public order, and social harmony. And really, the task before us is really to focus on the available measures that have been worked by international experts and communities and religious groups, the Resolution 1618 and other measures, the Rabat Plan of Action. And we really need to work with media, education bodies, equality body, human rights group to really attain, to really try to shift this criminal measure to blasphemy into what is called by Dr. Shahid as hate speech, legitimate hate speech law in line with the ICCPR. Right, I will hand now the floor to Professor Bielefeld to answer some of the questions posed by the audience.
Yeah, thank you very much. I would like to take up one question only, and that is the one focuses on the necessity principle. I think it's super important. So when talking about freedom of expression or freedom of religion, of course, we cannot avoid also the issue of possible limitations. And I have actually often come across a political rhetoric that easily accepts a human right by at the same time the government say, of course, we appreciate freedom of expression. We like this right, it is important, but, I mean, you know, within a minute or less, what will come is but. But of course, we have also to establish some order, thereby sometimes imposing limitations. The same with freedom of religion or beliefs, freedom of assembly, freedom of association, the yes, but rhetoric. And that is a pretty easy rhetoric, and it's a dangerous rhetoric because it seems to endorse human rights, but actually it doesn't really endorse human rights because, I mean, human rights are immediately put up. So, I mean, it's true that if you look into international human rights law, of course, you see limitation clauses. And everyone will agree, almost everyone will agree, I certainly will agree, that freedom of expression cannot be entirely without any limitations. Of course, I mean, we can imagine, and we know examples. And the same applies to other rights as well. But I mean, how can we somehow cope with that issue of limitations without selling out at the substance of human rights? And here the necessity principle really comes into play, because actually it adds a caveat to the caveat. Yeah, so of course limitations, yes, I mean sometimes may be adequate, but only if they are really necessary. And now here the decisive point is the burden of justification always falls on the government, or on those generally who deem limitations necessary, not on those who wish to exercise their rights or who wish to promote the rights for others. I mean, human rights should be always taken as the starting point. They are somehow given. They are somehow given, yeah, based, I mean, to quote the Universal Declaration of Human Rights, based on the recognition of the inherent dignity of all members of the human family. I mean, it's a matter of dignity. It's a matter of dignity that we always start acknowledging people have rights, and no one has to justify because they wish to exercise their rights. It's the other way around. Limitations, which sometimes may actually be needed, they require justification. And here the necessity principle is really an important one, because really the government has to say, okay, we are pursuing a very important purpose, and it needs to be a specific purpose, and the limitation that we hold necessary really is suitable for the pursuance of that purpose, for instance, preventing incitement to hatred. That would be a classical example. So in order somehow to keep the structure of rule and exception intact, always starting with rights of freedom, in respect for human inalienable rights, they are important. And any limitation, any restriction that sometimes may be adequate, I agree, has to be justified. And here the limitation criteria, here the necessity principle is really important. So somehow we don't have the structure of yes, but human rights, yes, but limitations, but it's a threefold language, yes, but. So somehow the caveat itself finds a caveat. So be careful. The caveat, the limitation must meet certain criteria. Yeah, so we have to justify that. And there are so many misunderstandings around that issues, and there's so much confusion, with the danger of really selling out the substance. That, I mean, here I think the necessity principle is super important. So I'm grateful for the one who raised that issue for the discussion.
Thank you, Professor Belfeld. Human rights really should be the premise, and any effort to seek for limitation must meet the international standard on limitation, and it has the burden of justification as well. So that's a very valid point, and it really added our knowledge about the international standard on limitation. And we have more questions. It shows how the public are really enthusiastic with our discussion today. So I will read out more questions. I hope you will bear with us. So the next question is, freedom of religion or belief and freedom of expression seems to be contradicting in this whole discussion. Is there a way to reconcile these two topics? And also the next question is, why questioning or criticism of religious texts is believed as sacrilege or desecration of religion, whereas harnessing religion for political gains is not considered as blasphemy or misuse of religion? Very interesting. And blasphemy laws demand grab serious debate in the parliament before passing these laws. It never happened in Pakistan. The mockery of its debate ends as believe in God, believe in my God, I do, otherwise I will kill you. So the next question is, public have this kind of understanding that freedom of speech have some kind of boundaries when it comes to hate speech toward religion. In Indonesia, blasphemy depends on public interpretation. There are no laws that specify what is blasphemy and hate speech. This absence of law have made government and law enforcement have no clear restriction, and implementation of the laws is blurred and unfair. Freedom of speech must be protected, and the state must not interfere with faith or beliefs that are not recognized in the country's constitution. There's no form of state protection to them. And it is even more problematic when there are discriminatory bylaws referring process. Is there any state obligation under international laws that could be cited? And the last question, what should we do to prevent discrimination and hatred against religions and beliefs, whether laws made based on the latest social issues will be a solution? Sure, so maybe I will hand this to Professor Belafat first, and then I'll go to Professor Naz and then Professor Shahid. The floor is yours, Professor Belafat.
Yeah, thank you very much. If I may pick one of the questions, because it's actually too much for all of us.
Sure.
I particularly like the question that wondered, or the person who wondered, why criticism of religion could actually be seen as something blasphemous. And I agree. Actually, I would say the opposite is true. I mean, simply assuming that a certain religious interpretation is frozen against any further development. It would be something like nailing the divine will. So now we have it, grabbing it, and instrumentalizing that. So actually, I would say this attitude of preventing any serious discussion, any serious development, somehow is itself blasphemous. Now, I'm using a term that I have confessed. I do believe in the reality of blasphemy. I still don't advocate blasphemy laws for that. Yeah. But nonetheless, I mean, it's really somehow it's a perverted attitude. So mainly I argue from a human rights perspective, but somehow, sometimes I switch, and I'm doing it here. So I'm not really using the human rights discourse now, but from a theological perspective, from a religious perspective, which is really a different perspective. It does not make any sense. It does not make any sense. And I remember a discussion a panel discussion with an Iranian philosopher, Abdul Karim Soroush, a rather famous Iranian philosopher, who said, I mean, would God be in need of human beings protecting his honor or reputation? Yeah, what is that? What a strange idea. Yeah, human beings are in need of protection, but God is not in need of protection. So the idea of using robust legal instruments, blasphemy law, criminal law, to protect God against something, I mean, strange idea, very strange idea. And to freeze interpretation actually is the ultimate degree of human arrogance. So my interpretation is the last one, because you can never have God's word without interpretation. So preventing discussion merely means you put one particular interpretation as the absolute interpretation. And maybe some Muslims would say this comes close to shirk. It's really, I mean, that in itself could be blasphemy. I share that understanding. Now, I've really now somehow changed the discourse. Still, from a human rights perspective, I have to insist, even in that case, I would not advocate blasphemy laws against what I consider blasphemous.
Sure. Thank you very much, Professor Belafat. I will now hand the floor to Professor Naz to make more responses to the questions. The floor is yours.
Thank you very much. I hope some of these questions will be put to the Thursday panels as well, because they're very rich and we don't have enough time. But maybe I'll also take Professor Bielefeld's strategy of just taking one element of it. there seems to be, I use this in a little bit of humor, but there seems to be a bit of subversion now that some people are saying, well, how come, you know, what happens when the state itself is sponsoring hatred? When there's state-sponsored persecution, discrimination, stigmatization, hatred, violence, what do we do there? And another question was, how is it that when religious texts are being used for political gain, and maybe we can say abused for political purpose, then what happens there? So, you know, we could say that actually we should be turning the tables on this. Maybe there should be people's tribunals set up that discuss the itself perpetuating this. And maybe that is a more appropriate response, because that also can poison societies. There might have been a historical element to division or misunderstanding between different communities. But when the politicians jump on this, and when the state sponsors this or uses this for electoral gain, or maintaining a patronage of legitimacy and authority, then it continues it and grows it, to a very dangerous level. Whereas if we were left to our own devices, one would believe in the goodness of human nature, that people do want to live alongside one another with the beautiful diversity that we have in our neighborhoods now, and would come to resolutions, if, you know, initially on a practical level, and then beyond it even much more deeply than that. And there is a hint of this in human rights instruments. For example, in the Madrid Final Act, it talks about the harm to the child when prejudices are taught through the school system. And also, you know, of course, all religions and ethical codes would find it well, you know, most, if not all, would find it hugely problematic that, you know, we then trying to respond to them. So in brief, I think I agree with you that even if we had a notion of this stigmatization and prejudice throughout society, we would find that many of the causes of it are not the random blasphemer or the one that gets media hype, but it is when it's institutionalized and structured within society through governmental channels, that this becomes particularly intransigent and difficult to address. But people can address it, can refuse to be politically manipulated, and can refuse to be, you know, give their votes to politicians that are trying to take advantage of hatred just for the sake of their own power interests. Not a very legal response, but I think this topic is far too important to purely look at it through a legal lens.
Thank you very much, Dr. Nas. And now I will hand it to Professor Shahid to make some more response to the question that were posed by the audience.
Yeah, thank you very much. To pick up where Professor Ghania left off, you know, the idea of faith for rights is that actually we need to engage more than lawyers in this debate, and also links with what Professor Bielefeld just now said by invoking, you know, his interaction with Abdul Karim Surosh. I think given Indonesian context, it may also be worthwhile looking at religious scholars and what they can say about, you know, addressing this issue. And I point out because, you know, if you go back, I'm not a scholar, but I dab a little bit in this. If you go back as far back as Ibn Taymiyyah, which is well known to the Salafi Muslims, and of course, the key person here is Imam Shatibi, his notion of the public interest, maslaha being a good basis for the authorities to make laws, the public interest, and his notion that Islamic law seeks to protect 5 essentials. And these, if you look at modern scholars like Abdul Karim Surosh and Khalid Abu Fadel, also if you look at one Indonesian frequent visitor, Professor Abdullah Said, they will tell you that these essentials does include protecting, you know, life, property, religion, sense of faith, and so on. So the idea is that these essentials provide a basis to frame laws on the public interest. If you look at countries where blasphemy laws are in operation, it becomes evident public interest is not served by these blasphemy laws. So you do have, even in the Islamic context, sufficient resources to argue the case against these laws. And just to pick up from Abdul Karim Surya's point, people like Abu al-Fadl argue that no, God is beyond benefit and harm. That's the whole point here. God is beyond benefit and harm. Therefore, human beings trying to come and defend God, like Professor Bielefeld said, itself looks like a blasphemous idea. So the idea is that sound religious arguments also. And I think if you look at the work of Abdullah Said, you'll find sufficient arguments to really look at an Islamic case to abandon this as well. Then if you want to go away from religion, let me also get to non-law-based, non-religious-based community, development scholars. I think everybody is committed to the SDG agenda with its idea of leaving no one behind. And the SDG agenda go for an education.
Gave so much emphasis to the fact that this concerns all of us and also impacts majorities, that I just wanted to go back and say, obviously though, vulnerabilities that minorities and others face will always make them the first easy victims of any kind of blasphemy effort. So we shouldn't forget that, and we should, if we are looking at the impact of blasphemy laws, we shouldn't be looking at the elite neighborhoods and the elite or the majority. We should be looking at the minorities. So let's look at any harm that is becoming on minorities in order to judge whether there is any benefits or what are the consequences of the blasphemy law. And secondly, let's unpack what are the incentives for why is it that Parliament is considering the blasphemy law? Let's unpack that and address each of those singularly, but in a rich way. Let's not use the law as an axe to deal with this. This is the age of maturity and complexity, and there isn't an easy answer to those feelings of blasphemy that may arise in society. And finally, of course, the law has a role, but I think we are saying that the primary role of the law here is to curb its involvement, to have a framework, to consider these very rich standards that are proposed, and some of them are binding at the international level. But the primary role of all of us is to look at the non-legislative measures, because the law is the tip of the iceberg. Underneath it has to be all those, the scaffolding and the support networks of educationalists, human rights defenders, etc., etc. Thank you.
Thank you very much. And Professor Shahid, please. You're muted.
Summed up it well, but I just want to sort of point out two things here. One is that if you look at the experience of other countries, from being victimized by anti-blasphemy laws. And there are cases in which people who at one time may have been pointing the finger at somebody else, and I hear the case of Nasr Hamid Abu Zaid here, where one of his, if you like, accusers subsequently got accused himself of the same blasphemy provisions he was invoking against the professor. So, it can affect everybody, because, anybody can abuse a law that is open for abuse. And even in your own country, you could be victimized. But if you look at the minorities around the world, nobody's in the majority everywhere in the world. Every community is a minority somewhere. And if you use, religion when you're in a majority in ways to advantage you over the minority, you find that elsewhere the reverse is happening. So, what you argue for yourself, you need to be able to defend for other people as well. If you don't have that empathy, then obviously you will never get anywhere. So it's important to look at what really happens with these laws. Second is a point that Professor Bielefeld stressed. These are something is an ongoing challenge. We have to keep working at it, because attitudes change, platforms change, means change. The online dimension has again ballooned the scope for both love and hatred. So blasphemy and its persecution goes on. And we see in countries where certain provisions which became dead letter laws, became inactive or became dormant, suddenly gets invoked in a provision. So it's a continuous challenge to make sure that the voices of sanity, wisdom, and inclusion always prevail over those of exclusion and bigotry. It's a continuous challenge all societies have faced at all times. And I'm really glad you're doing this right now at this important time in your country. I'm also glad that you have other events coming up, which I look forward to joining. But certainly, I think we all need to work together in your country and elsewhere to ensure that voices of reason and sanity prevail over those of hatred and bigotry. Thank you.
Thank you very much, all the excellent speakers. I would want to quote everything from what was spoken during the discussion, but just to say that it's been really fulfilling and inspiring discussion, and it's been definitely useful for us moving forward. But if I may, I would want to emphasize a couple of points that we had during the discussion. Blasphemy, insult to religious feelings exists, but still blasphemy laws is not conducive for human rights, public order, and social harmony. Hence, we in Indonesia have a very big homework in trying to shift from criminalization of the blasphemy to criminalization of advocacy of national, racial, or religious hatred that constitute incitement to discrimination, hostility, and violence. We need more interaction with international experts. We need to invite the UN Special Rapporteur to assess the situation in the ground and come up with recommendations for the state. And our task indeed requires a greater range and responses from various stakeholders. We cannot rely on the legal reform or legal means alone, but a lot to do with building social cohesion, social reconstruction, and also public education. We need to seek a new form of harmony, and the harmony that is seen as a work in progress, which requires a little more noise and much more tolerance. And indeed, it is a big homework for us from the discussion that arose from the audience earlier, with us, especially APHR and IPP-FoRB, who are dealing with parliamentarians, on how to actually generate champion of lawmakers who themselves are the product of politicization of Islam or any other religion for their electoral gains. So with that, it's been really overwhelming in a positive way that we had this very important discussion this afternoon. But before we close the session, we would like to remind you that our fourth session will be held on Thursday, on the 27th of August at 2 p.m. Jakarta time. And it will look into cross-regional experiences, presenting the viewpoint from the OIC, ASEAN, and European countries. With that, I would like to once again extend our profound gratitude to our excellent speakers. It's indeed the forum of world-class experts, and we are really privileged to have it this afternoon. Thank you very much for your presentation, insight, and contribution. And to all the audience for your active participation. We hope to see you again in the next